Good morning, good afternoon, good evening, wherever in the world you might find yourself today. It's another Thursday. We'll Work for Food, the New Possibilities Hour. As many of you know, this is a program that was founded in the spring of 2020 by Natalie Armstrong Motan as a way of giving back, during the pandemic and all. And we've just kept on going, and it's just such an amazing thing. There's no payment required, requested, or anything. It's all donated from the goodness of the heart of the speakers and all of us. It's a great audience. We merely ask that if you are able, that you make a donation to a food bank of your choice or the one suggested by the speaker. And so that said, today we have one of our own, Michael Schwimmer, who's recently become part of the We'll Work for Food team, which we're very happy about. I will let David Schraga introduce him in a moment. But before we get going, let's see, Natalie, do you think that you could tell us what the running total is of donations to food banks around the world, of which we've been told?
I absolutely can. The new total, Jean, is $885,245.91.
That's just amazing. That's millions, 8 million, 10 million meals. It's just amazing. So thank you all so much for your continued support. We've got a great lineup of speakers through the rest of the year and are already booking into next year. It just keeps getting better and better. So without further ado, let me turn it over to you, David. And if you would go ahead and introduce today's speaker, Michael Schwimmer, then we'll be off and running. Thank you.
Well, great, Jean. Thank you so much. Thank you, everyone, for attending. It's always a pleasure to be here with this community. Our dear friend Michael Schwimmer is a fantastic speaker who has a very exciting program for us today. It's going to be very insightful and I think very useful and enjoyable for our audience. Michael brings to his mediation practice really the depth and breadth of experience that comes from a career spanning law, executive leadership, and global business as well. With a steady hand and a sense of humor, Michael tenaciously pursues resolution by working with parties in their counsel to create a common ground for settlement. By way of background, after a decade of international law practice and corporate counsel roles, Michael spent more than 25 years leading media and entertainment organizations through growth, high stakes negotiations, and the legal disputes that happen along the way. As a CEO, a president, an executive vice president, and in other senior roles at media companies such as Televisa Univision, Sling TV, Fuse Media, and Dish Network, Michael oversaw and negotiated a wide range of business agreements representing billions of dollars, involving intellectual property, licensing and distribution, investment, joint ventures, partnerships, M&A, equity and debt capital raises, as well as corporate governance, among many other issues. As you can tell from some of the companies Michael has worked for, he is fluent in Spanish and Portuguese with deep experience in Latin America. Michael also offers a multicultural and international dimension to his mediation practice as a result, and it's part of how he contributes to the Will Work for Food project in terms of being a liaison to the community in Latin America as well. Michael's program today is called Context is King in Business Disputes, a view from inside the boardroom with a mediator and former media CEO. For many lawyers in media and mediators, litigation is like a puzzle to be solved. And the big questions are how questions, how to win the lawsuit, how to facilitate a settlement. But before the how comes the why. Why did the company breach the contract? Why did the company decide to sue? The answers to these fundamental business questions are what drives so much work for the legal community and part of what Michael is going to talk to us about today. And I believe with that, Michael, we can turn the presentation over to you. You have the floor. But before getting started, perhaps you can tell us a little bit about the food bank that you've designated today. And the information concerning that food bank will be in the chat for anyone who's looking for it in order to try and make any donations to the food bank Michael has designated.
Sure. Well, thank you for that lovely introduction. My parents would be super proud if they had heard it, so I appreciate that. The food bank for today. I'm born and raised in Los Angeles. Spent a lot of time elsewhere, but I'm an LA boy, and so the food bank I would designate is the Los Angeles Regional Food Bank, and that can be found at lafood.org, lafoodbank.org. So with that, yeah, look, I'm happy to be here today. It's happy to be associated with Will Work for Food. It's an honor to share a bit about my story and some perspectives that I hope are helpful regarding business disputes. I say business disputes as opposed to commercial litigation because disputes, happen before litigation, and litigation may be the final manifestation of that dispute, but it doesn't always happen. Full disclosure, I'm getting over a cold, so if I feel the need to cough, I'm going to hit mute, step away from the camera, come back so I don't have to subject you to my virtual germs. So I thought today we could just start for fun with the title of the talk, which is "Context is King." Context is king comes from a phrase some of you may have heard called content is king. There's some debate about when that phrase first came into the zeitgeist. I came into contact with it in the mid 90s when I was in the cable and satellite pay TV business. And there was a raging debate about what was more important, content, because content providers would say, well, that's what people come to see. They want to see my movie, my sports game, my reality TV show. But the folks on the distribution side that control the means of distribution, primarily cable operators at that time, would say, well, gee, your content isn't getting into the home without my pipes that cost me billions of dollars to build. So distribution is king. And I think at this point at 2025, kind of the jury's in, right? The content is pretty much king. You can get any content almost anywhere you want, anytime you want it. But it seems quaint at the time. But there was a real debate about what was more important, the content or the means of distribution. But coming back to context is king. So what does context is king mean? And what I mean by that is that every business dispute lives within an ecosystem, right? And that ecosystem is the commercial ecosystem in which that company lives. Every company lives within what I would say, its own industry, whether you're a McDonald's and your commercial ecosystem is your franchise agreement with McDonald's. It might be other fast food places that are in your neighborhood, or if you're where I come from and the ecosystem was the pay television business, where you had very, very large companies like Disney and NBC, that had high, high amount of content across multiple areas of their business, be it cable and film and whatnot, and much smaller guys. And I've been on both sides of that. And by the way, a smaller company in my world back in the day might be a company that had 200, 300, $400 million of revenue. That was a small company in a land of giants. So the important thing to remember, though, is that this ecosystem lives independently from the merits of any dispute. So, it existed before that dispute comes into being, and it's going to be there after that dispute is resolved. And so I think about it a little bit differently than maybe the traditional way of thinking. Traditionally, lawyers and mediators, are really trained to think about what are the facts, what's the law, and who has the best chance of winning if this dispute actually ends up in a court in front of a jury or in front of a judge. And in my experience, the facts and the law are really much less important, and I would say even secondary to the overall context in which that business dispute lives. So why is context so important? That's the question for today, and that's my goal. My goal is to provide some insight into how corporate executives and business managers think about disputes and potential litigation. Like, what are they thinking about it at headquarters before the dispute happens, right? I mean, typically, no, very, very infrequently in my experience, does a lawsuit just land on your desk. There's trouble brewing, that's going to come. And so people are talking about it, they're thinking about it before that lawsuit ever gets filed and after it gets filed. What are people thinking about? What are the merits? Not just what are the underlying merits, but do you fight? Do you cave? Is there middle ground? What are the drivers that are making people sort of chart out their options and make a decision about how they want to proceed? So that's kind of what we're going to get into today. I want to pause for a moment and sort of give you a view in terms of how I come to this topic and sort of my own journey, because it might be a bit informative. So from going from lawyer to CEO, I encountered a number of sort of stages that sort of led me to have the view that I have. So about 4 to 5 years into my practice, which was largely transactional, I just found that I was getting much more interested in my client's business than my own, quite frankly, as a legal advisor. And that was sort of the first clue. And then the second clue was when a deal was done, I felt like this tremendous sense of loss. Like they're not calling me anymore, and we're not getting together anymore. And I realized that what I really wanted was a monogamous relationship, a monogamous professional relationship, but a monogamous nonetheless. And that's when I decided to move in house, where I felt like I could be, I would be more tied to a single company trying to chart its journey. But when I did that, what I found was that I began to have a different understanding of where deals fit within the company's overall objectives. So what, from an outside counsel's perspective, I might have seen as sort of, a really important transaction, once I was inside, I could see it was probably pretty peripheral to the overall strategy. But the opposite would also happen. What I might have seen as a run-of-the-mill deal, could have been front and center for what that company was trying to achieve. So that gave me a lot more perspective into where deals fit within companies' strategies. And then once I was in house, I was very fortunate to be with a company, Dish Network, back in the mid 90s. It was growing very, very fast. And it was growing so fast that it actually didn't have enough business people to chase down their deals. And so what would happen is a deal might land on my desk. I'd have one meeting with the business guy and he'd say, okay, good luck, Michael. I got to go do something else. And I would end up doing basically the entire transaction, both the business negotiation as well as the legal work. And I guess after a while, the company said, okay, well, look, Michael, you're more valuable to us on the legal side. We'll find another lawyer. And that's when I moved into management full time. But the point is, for purposes of today, is that as I was getting deeper and deeper into the business, what I was realizing is that the contracts, the law, even lawsuits, were really becoming, peripheral. Not to say that they were distractions, but they were much less important to me than core issues of market share, growth, profitability, operational stability, and because that's really what the business guys focus on. And over all of those years, I got to work with a lot of good lawyers, some great lawyers from some of the best firms around the country, and I got to work with some not so good lawyers, to be honest. And what I want to do today, hopefully, is impart some of what I found to be particularly valuable in working with both in-house and outside counsel throughout that journey, because I worked with lawyers all the time. I've always had deep respect for them because I come from that world. And after a while, being someone who was a lawyer and moved into business, I developed a much deeper appreciation for very effective counsel, but what it meant to be effective counsel beyond just having what I would call subject matter expertise or particular skills. So the headline for today, if I were to give it a headline, would be who's right and who's wrong comes later. So if who's right and who's wrong comes later, like what comes first? Like what's more important than who's right and who's wrong? And I'm going to talk about 5 different considerations that I would have in mind. It's not an exhaustive list. It's 5 things that I came up with that I thought were worth talking about. The first 3 of them are what I would say really core And the last two are just things that are of particular interest to me. So the five, I'll just tell you what they are up front. So the first one is who are the players? Like who's actually involved in this business dispute? We'll get into that. The second is how big is the dispute relative to the size of the company? Is it a $10,000 dispute in a company that makes $500,000 a year, or is it a $10 million dispute in a billion-dollar company? Those are very different, very different scales, and there's all of the variations in between. But probably the most important is what's the relationship between the companies in the dispute? How much dependency or reliance exists in that relationship? The last two are, sort of interesting to me, which is this a life or death, like bet the company kind of dispute, or is it what I would call a business as usual dispute? And then last, and this is my own personal favorite topic, is how does litigation affect the company culture internally and separately? How does litigation affect the company's reputation in its market? That's also, in my view, a particularly important consideration. So I'm going to give you one caveat first. So my background, even though I was involved in what are called B2C businesses, business to consumer businesses, most of my negotiation, most of my legal work, it's all been with other companies. So the context in which I'm speaking to you today is really two companies on either side of a dispute. Obviously, there are variations of multiple companies, but it's basically, I'm not talking about family law or consumer litigation or even employment. I'm really talking about business to business litigation. So going back to the first consideration, like who are the players? This is probably the easiest one to get your head around. Are they big? Are they small? Are they mature? Are they getting started? Why is this important? The first most obvious reason is cash is king, right? Litigation is expensive, it takes time, and smaller companies, if there's anything they don't have cash and they don't have time, right? So obviously, as you go up the scale and companies are more well-heeled, they can take more time doing things and they have more resources to expend on that effort. Another kind of what I would call less obvious reason that size matters is because size is often can be correlated with experience, and experience in litigation is important, right? Because you want to be able to know that the other side, they're veterans. They've been through this. They have a process. They're going to put this litigation through the legal department. It's going to have a very methodical approach. They're not going to do anything crazy. They're probably not going to surprise you. So larger companies tend to be more predictable in the way they engage. Um, oh, well, let me give you one example. So my first role as CEO after I left Dish, I went to work for a small cable network that I had previously sat on the board, and this cable network was venture backed. Venture backed meaning that its primary investors were venture capital investors. These are folks that they go out, they raise money from people they call limited partners, but it's basically pension funds and other large public funds that they're looking to get, they put maybe 2% of their portfolio into venture backed funds because they got to keep the money safe for everybody else. But the bottom line is they're looking for a big return on their money. And the venture guys, they want 10x, 20x. And the first time I thought about, well, maybe we should sue this other company. They've done us wrong and we're right. And I went to my board and I started talking to them about whether or not it made sense to sue this company, and their eyes almost popped out of their head, right? I had come from a bigger company where litigation was not that unusual, not unusual at all. And I can just tell you that they just hate the idea of giving money lawyers to giving money to lawyers to spend on litigation. They want it to go into the product, they want it to go into marketing, they want it to go into growth. And so, CEOs may have a lot of decision-making power, but they still have bosses, and their boss is called the board of directors. And so that was sort of my first big lesson that when it comes to litigation, smaller companies have real constraints and it's not just we have less cash, it's what's the best use of that cash. So the second consideration is the relative value of the dispute with respect to the size of the company. There are a lot of variations on the theme. You have a big company involved in a dispute with a small dollar value. You have a small company involved in a dispute with a big dollar value. And what I would think about in that regard is it would help me gauge like how much of a priority is this lawsuit for the company. Because if it's a bigger priority, they're going to spend more time on it. They might be um, willing to fight harder, spend more money on it. If it's a smaller priority, maybe they're going to want to get rid of it sooner. But people tend to fight harder when the stakes are higher. So understanding the economic role, the economic size of that dispute with respect to the size of the company was always sort of a critical factor that I would think about as I'm thinking about the strategy for a particular piece of litigation. The third factor, is probably the most important, right? The third factor is what's the relationship between the parties? Like, and specifically, I'm focusing on leverage. So what does leverage mean in a commercial context? Because leverage, sometimes has different interpretations, and sometimes it's not even a positive interpretation. I think about it neutrally, but because it is sort of a neutral concept, but another word for leverage is reliance. What is the level of reliance that one company has on the other company when those two companies are involved in a fight? And that can manifest itself in different ways. So you might have a revenue reliance, such as one of the parties represents a big part of the other company's business. Um, you can have what I would call an ability to operate reliance. That would be, say, in the case it was a fight between a company and a software developer, and the company used that software for the manufacturing of its product. And if they didn't have that software, they couldn't manufacture the product. So that's what I would call an ability to operate kind of reliance, technology reliance. And then there's IP. So IP could be trademark, could be patent, could be copyright, and you can have all sorts of reliances based on intellectual property. So an example that from my past, which I'll call the SpongeBob surprise. Back in the very, very early 2000s, when I was with Dish Network, and this is all public record, we sued Viacom. Viacom at the time owned all of the CBS broadcast stations, but it also owned cable networks you may have heard of, like MTV and VH1 and a children's network called Nickelodeon. And all of those channels, of course, are copyrightable. They're all they are the property of Viacom by virtue of their ownership of the copyright. And they were threatening to take down the channels, and we went to federal court. I remember in San Francisco, we filed an antitrust lawsuit in this case. We got the temporary restraining order, which kept them from taking down the channels. We ended up losing the preliminary injunction, which meant that that Viacom could, once the contract expired, take their channels away. But we had millions of loyal customers. We had hundreds of channels. We thought, well, okay, we'll lose some channels, but our customers will just go on their merry way until we figure this out. Maybe they'll be upset, but not terribly upset. But as soon as the channels came down, we thought we would hear from the CBS viewers, not to say anything negative about CBS at all, but what really made the phones ring, which just was the biggest surprise, is it was all the angry parents who were screaming at us that SpongeBob was no longer there for their kids. And so, it was like, based on what I would call the SpongeBob surprise. Let's just say we settled. We settled soon thereafter. And so that's a case where even though we were a big billion-dollar company, we had a pretty heavy reliance on the copyrightable material, the material subject to copyright, which we delivered to our customers. Another example of reliance, when I was running a cable network called Fuse, we had a large distributor, and the ecosystem of the pay TV business is kind of a funny one, right? Because you have these, as I was saying before, these giants, right? You have these giant distributors, right? So that would be like DirecTV and the company I was with, Dish Network, and at the time there was Time Warner Cable and Charter and Comcast. You had large programmers, and then you had small programmers. So small programmer, we were a small programmer, and a small in the day, we probably had anywhere between 50 to $100 million, but that was a minnow. We were a minnow in this sea of giants. And our margins weren't huge. And so one of our distributors took a very, what I would call, aggressive interpretation of our contract, and they just deducted $1 million from what they owed us. And so the next month, when our check showed up, we thought, like there was like $1 million hole in it, and that was beyond painful. And we were very confident that we had a better view of the contract, and that they were claiming allowed them to do that. But upon reflection, there was just no way that we were going to sue them. We couldn't sue them because they were a very large distributor of ours, and we were going to come up in a renewal discussion with them at some point. And the idea that we were going to sue a company that we relied on very much for our, we call it our economic health, was just not in the cards. So that's an example where, despite a large economic, or because of the large economic reliance, we just had to, quite frankly, turn the other cheek. And so merits of the lawsuit, facts, law, irrelevant, right? What was really relevant there was the underlying interest that we had in maintaining that relationship with our distributor. That's how we got our programming to customers, and that's how we got paid. So an offshoot of this question of leverage, I would put in the form of a hypothetical question, just to hopefully keep things interesting. So why would a company that has a very weak case, and let's assume that it has good lawyers, and its good lawyers said, "Hey, Mr. CEO, you have a really bad case." Why would that company still go ahead and file a breach of contract suit? Well, there are a number of reasons. It might do it to tie up the resources of the other company. It might do it because it sends a message to that company, or sends a message to the broader industry that those companies exist in. And it might do it, and this is not infrequent, it might do it to improve its position on a separate, unrelated negotiation they're having. It might do it because basically it's trying to get more cards in its hand, if you will, to play. And that was probably, going from naive to not naive. That was probably the biggest surprise for me as I was going through my journey from lawyer to business guy, was how often litigation can be just another tool in the business toolkit, right? It's for certain companies, for certain executives, it's not a moral thing, it's not an ethical thing. It's just a business tool that you might use like a hammer or a nail or a saw, and it either helps get you to reach your objectives, or it doesn't. And it can be used in that form. So the note here for mediators would probably go like this, that sometimes if you're in a negotiation and you have a corporate client sitting on one side, and you want to tell them, "Hey, your case is pretty weak. This is going to cost you a lot of money to litigate. Wouldn't it be better to settle?" Realize it may well be the case that this client absolutely knows how weak its case is. It absolutely knows how much it's going to cost. They win eyes wide open. That was the point, right? So it doesn't mean you wouldn't raise it, but just understand that for more sophisticated parties, they probably already got there, right? So a side note on this issue of leverage would be that sometimes, very once in a while, being small is actually can be an advantage. Not often, but sometimes. So if you're a small company and you're fighting with a company that actually is subject to government regulation, so in my case, it could be a telecom, a company that had a broadcast license, a company that had licenses to operate cable systems. then that company has what I would call ties to the government, that it's going to want to keep those relationship with government officials, with government agencies, very crisp and clean, and its reputation stellar. And what they really don't want is to be seen as a bully in the marketplace. Another example would be if you're dealing with a company that is going through a merger, and that merger requires regulatory approval. It could be the Department of Justice, it could be the FCC. That's another example where that company is relying on government officials to have a pretty good view of its reputation. And so if you're a small company and you're kind of in the middle of a fight with a big company that's going through some sort of merger approval, people will want to hear what you have to say. And that can provide what I would call, some non-legal extra influence that you might not otherwise have. So the fourth consideration here, which I call the life or death, bet the company. This is a situation where, again, like most of what I've been talking about, regardless of the merits, it's a situation where the company just has no choice. It has to fight, even if it doesn't have the best case, because if it doesn't fight, the consequences could be devastating and possibly, end the company's ability to operate. So the closest probably I came to this was when I was running a couple of cable networks. I think I was telling you Fuse and Fuse FM. Well, actually, before then, the company was called CTV, and the interesting thing about this is our mission. Ancient history, but our mission was to serve the Hispanic community with English language programming. The theory was, the market theory was there was a lot of Spanish language programming out there for Hispanics that speak Spanish, but there are a lot of Hispanics in America that consume media in English, but there wasn't really good outlets for them to see themselves represented in a positive form, not the maid or the gangster, but actually the doctor or the lawyer. And so we had this company called CTV. The issue with CTV was CTV, C as yes, as in Spanish, is a Spanish language name. And so we had this issue of going around telling people why they should carry our English language channel, but we had a Spanish language name to the channel. And that caused no end of confusion. So in our wisdom at the time, we decided, okay, we need a name that sounds like kind of Spanish, but isn't really Spanish. And so we came up with the name Nuevo. Now, for those of you that speak Spanish, Nuevo means new. Nuevo it's not even a word. It doesn't mean anything, but it sounds like it could be Spanish, right? So we came up with this name Nuevo. We actually did this huge deal with Jennifer Lopez, who came on as an equity partner, and she was going to do all this marketing for us. And we launched this marketing campaign. And as soon as we launched the marketing campaign, like a lawsuit landed on our desk from Diageo. Diageo is the largest distributor of alcohol in the world. They have Smirnoff and Johnny Walker and Bailey's. And lo and behold, they had a small liquor brand called Nuvo. And they thought, hey, man, this is infringing. And, Jennifer Lopez sings in clubs and our alcohol is in the club. And they had this argument as to why it was copyright infringement. And I'm not saying they had the best argument, but they're a much bigger company than ours. And under normal circumstances, we would have found a way to change our name, do something. But we were so deeply invested in the name that there was no way we could go back. And so we just, we said, look, whatever it costs, it costs. We just need to, be able to keep the name. And fortunately, we had a good lawyer, and he helped us out, and we fought for a while, and then we settled. But that's an example where sometimes the stakes are just such that you have no choice but to move forward. Your options are zero, right? Move forward or shut down. Like that's basically it. So the last category that I'll talk to you about, and this is an area that I have particular interest in, and that's the idea of litigation as part of company culture, and litigation as part of company reputation. So, there's sort of this internal external factor, right? So the internal factor would kind of go like this, that when there's litigation, employees are very aware. At least in my experience, big company, small company, for the most part, everybody knows that that you're involved in litigation. And it is a team effort, as you litigators out there know, and mediators who are probably former litigators know. It's a team effort because you're involving your finance department, you're involving your marketing department if it's a marketing dispute, you're more involving your engineers if it's a patent dispute. The bottom line is everybody knows that there's litigation, right? So I, as a CEO, I used to take advantage of that and use litigation as a way to build esprit de corps. Okay, we're all in the same team, we're in it to win it. And quite frankly, it can be a very powerful tool to bring people together when a smaller company is involved in litigation. But there are pros and cons, right? On the pro side, for a small company, um, as I said, it brings people together. But the downside of it is it can make employees really nervous, right? Like, hey, we're involved in this litigation. What if we lose? Am I going to lose my job? My wife's pregnant. I can't have volatility in my life. I've actually seen employees leave the company because it just, it made the environment feel too risky, right? And so you have a big challenge in the smaller companies with litigation because it makes people nervous, right? In bigger companies, it's a different problem. And the different problem there is you don't want to be perceived as a bully by your employees, right? And as you know, people, some of them, they wear their company logo, on their sleeve, like physically or metaphorically, right? And people self-identify with the company they work for, and they don't want to self-identify with a bully. They don't want to see themselves as bullies. They want to go home at the end of the day and say, I'm doing God's work. So, that's a real issue if a company gets perceived as litigious. So from an external perspective, if you develop a litigious sort of reputation, like competitors are watching, partners are watching, and a couple things can start to happen. Contracts get harder to do, right? Because your counterparties, they see you as somebody that you're in court all the time. There must be something that's going on. Are you trying to get out of your obligations? And suddenly the drafting gets a lot tighter and you have less room to maneuver and those deals can take longer to get done. And the other thing is partners. Partnerships require trust. And if you're dealing with somebody that you think is litigious as a company, as a corporate culture, you're going to think twice about whether or not you're going to throw your lot in on some important joint venture or some important project with a company that seems to find itself in the news often because of lawsuits. So that's what I would say about what I would call, lawsuits as it relates to company culture and company reputation. So that's pretty much it. I have a couple thoughts. So one is if you've gotten the idea that I've spent some time talking about power and leverage, it's true. I have, right? Power is one of those value-laden words that people don't, inside companies, people don't talk about. People don't walk around the halls of their business saying, yeah, we're a powerful company, right? Because it would be considered rude and there's this negative connotation. But the fact of the matter is power exists. It exists in a very palpable way in business relationships. The image that comes to my mind is if you gave somebody a car that could go 200 miles an hour and you said, there's no speed limit, how fast do you think that person's going to drive? Do you think they're going to drive 65 miles an hour? They got a car that can go 200. They're going to go 200. They're going to go 195, right? Because they can. And that's a lot of what happens in business. People exercise their power because they can. It's the world we live in. And so the more you can understand how that dynamic works itself into business relationships, the better you can understand what's going on behind a lot of these disputes. From a lawyer and a mediator perspective, if I had any sort of takeaway, I would say just know your client. Like know your client, not just know the facts, not just know the law, know your client's industry, know what they think about on a daily basis. As a CEO, I would spend my day thinking about what's the competition doing? How are consumers reacting to my product? Do they like it? Do they think it's too expensive? Is it high enough quality? Do I have the right people on board? And so as a business manager, I always appreciated the legal professionals who took a deep interest in my company, and not just the dispute that they had been hired to work on. If it's outside counsel, if it's in-house counsel, it was always the lawyer that came to me and started out with, where does this fit within our business strategy? Where does it fit within our corporate values? What's the big picture? And then we might get, as a secondary conversation, what's going on in this lawsuit? What are the relative merits, the facts and the law and so forth. But that to me is a primary differentiator between what I would call, a very top-notch legal professional, someone who deeply understands their client's business and is very attuned to it and understands how it impacts the broader decisions around that dispute, and someone that just looks at the facts and law and says, okay, here's how we can win this thing. So that's kind of those are my thoughts for today. I don't know where we are on time, but I'm happy to take any questions if there are any.
Uh, well, I'll jump in here, Michael, and say that was a really fantastic presentation and really gives a great insight into the perspective of what folks are thinking about in-house as the business people. So thank you very much for sharing that. I have some questions as well, but there's a question in the chat we can start with. David Geffen had a question. David, if you want to unmute yourself and maybe ask your question and follow up, please feel free to go ahead.
Sure. In avoiding litigation, what creative ways did you find to resolve disputes that took you out of your lawyer box or litigation box and caused you to, find another way?
So for me, if someone is suing, or about to sue, I would always want to know, like, what happened. I think everybody to start wants to be heard, and often people get frustrated and they feel like they're not being heard. They feel like no one's paying attention to them, and so I would always start out with, just tell me everything you want me to know. And after people have the opportunity to get everything off their chest and not be interrupted and not be what I would call debated, already you're, I don't know if you're halfway to solving the problem, but you're much further along. And then the next question is, well, what would make, what would make you satisfied? Like, and there may be things, quite frankly, that, I couldn't do, my company couldn't do, but there typically are some things that, quite frankly, not only could we do, but would be in our interest to do. And then the last would be, people want to grow. They want to they want to grow. So whatever problem they have, at the end of the day, businesses are organisms, and if you don't grow, you die. You die. It's very, very hard to stay the same forever, right? So I would be looking at that person and say, okay, we have this problem. Let's look a little bit more into the future and say, what can we do together that would be great? What can we do together that would help, your business grow and my business grow, so we can build on this partnership and make lemonade out of lemons.
I mean, it sounds like you're really now you're starting to describe something the mediators do. And so sort of
Yeah, absolutely.
launching off of that, you talked about the importance of knowing your client's industry. And I thought that was such an important subject to get into. And you talked about it from the perspective of a lawyer who's helping a client. But my question for you would be, how does that translate into your mediation practice? And what are some sort of techniques or approaches you might utilize to try and unearth that as well? I imagine it translates to what you're trying to do when you're trying to build rapport as a mediator as well.
Absolutely. Look, when I mediate, I find it very unsatisfying and difficult, to just get mediation briefs and go from there. The fact of the matter is, it's really helpful to know something about the business, about the challenges. So if I have a little time to do research in advance, then obviously I will absolutely do it to get a better understanding. Sometimes it's as simple as a Google search just to get the headlines of what's going on in that industry. The other thing is this is really what pre-mediation calls are about. When I speak to a party prior to the mediation, it's not really about what's in the brief. It's about what's going on in their life, what's going on, behind the scenes that sort of impact indirectly this dispute, right? It's all about, in mediation training, they call it uncovering interests. So that's one way to put it, but it's really just gaining a deeper understanding of the things that are not in the brief.
What kind of questions are you asking? From the business perspective, right? I mean, what are the kind of things you want to understand going into it?
Well, let's say if it's a sale gone wrong, I'll give you like a sort of maybe the most mundane example. Let's say it's a big contract to sell a bunch of widgets and it went wrong. Well, by the way, if that can happen, so that could mean someone's not going to get a bonus. It could mean they missed their quarterly numbers. It could mean any number of things that have what I would call a psychological and economic impact on individuals, right? That's going to create some emotion, right? Also, in a corporate environment, people spend a lot of time concerned about their reputation. How does this impact the people that are involved reputationally? You might have somebody that's pursuing a case, and I've seen this happen, where they're pursuing something not because they have the best case, but because, quite frankly, they're embarrassed, right? And they're going to show that they did not make a mistake. They're right, right? But the fact of the matter is, so you want to be sensitive to what's going on with the parties. They're understanding like what goes on inside of a company because they have their own, they're different environments. You have your family environment. You have when you were in high school, God knows, we all remember what it was like to be in high school. Well, when you're in a business, that's its own environment, right? You have, you have all the relationships between the parties. And so not between the parties, but between the people inside that company and understanding the dynamic, in some cases, the political dynamic is going to help you understand why they're approaching the suit the way they are.
That's very helpful.
So,
And Michael, I've got a question for you. So many times it's attorneys who've been in practice as practicing lawyers in law firms that then end up moving into mediation or other fields. For someone coming from a business, a corporate environment, can you maybe tell us what your experience has been like moving into becoming a full-time mediator? There are plenty of people who move from the corporate world into mediation.
um, so from business into mediation, like I just, my experience is it's been sort of a natural transition, simply because I feel like I spent a lifetime um, dealing with people that have different opinions and trying to get them on common ground. It might be my opinion with a potential business partner and trying to get him to see things enough my way that we could do some important piece of work together that would be helpful for both of us. It might be two people coming into my office about some dispute they have over a particular direction. But I think the skills that one develops in a business role, it's certainly at a certain, as you get sort of higher up the food chain, if you will, and you're dealing more around strategy and deal making and less what I would call the execution of it. I think those skills, very much are the same as skills that mediators need to have, and that revolves around listening, creative thinking, bringing people along, helping them understand that they're not going to get everything they want, but half a loaf is probably better than nothing. So I hope that answered your question, Gene.
Sure, but I'd also was curious, been curious here about the practical, logistical aspects. I mean, if you've been a lawyer in a law firm that does litigation, you know all kinds of lawyers who litigate. So to move and have a mediation practice, where do you go then? So how do you get going?
Yeah, no, that's fair. I guess, look, clearly, um, in my case, I knew that going into mediation wasn't the same as like getting another job as a senior executive, or no one's hiring me simply because, I got a lot of new subscribers for Sling TV, so they're going to hire me to run the next streaming business. So I think you're asking me about building my practice, and is that sort of the focus of the question?
Well, essentially, for anybody
Yeah,
who might be
sure.
listening to this that is in the business world, the corporate world, maybe
Right.
they're not even a
Okay.
lawyer. How do they get
Right,
going?
right. Okay, yeah, okay, got it, got it. So look, I'm really fortunate that during my business career, I worked with a lot of lawyers. And most of the lawyers I worked with, were transactional lawyers, although I was involved in a fair amount of litigation. I hesitate to tell you, but I have probably been deposed 50 times. I've been on the witness stand in federal court and state court. I've fortunately or unfortunately, depending on how you think about it, I've spent a lot of time around the courtroom. Some of that has to do with the fact that the pay TV industry, at least when I was in it, was there were a lot of lawsuits flying around, and we happened to find ourselves in the middle of a bunch of them. So I do know a lot of litigators, and a lot of those litigators work at very, very large firms, and they have entertainment law departments, and they've been kind enough to introduce me to them, and some of the transactional work that I did obviously put me in touch with a lot of lawyers. So my Rolodex isn't the same as it would be if I had been a litigator my whole career. But it's not. I'm not starting from scratch. How is
I
I
didn't
get
think you were, and I'm sure anybody who wants to be a mediator is not starting from scratch either. We all have our connections.
so
When there's a general counsel, a corporate person, maybe not even there as the lawyer for the defendant or the plaintiff, but is there at a mediation representing the company even. Is there anything in particular you would share with the mediators on this presentation here on the Zoom here as to what they might like to hear from the mediator, how they perceive this? Maybe they're not experienced with mediation, maybe they are, and I'm sure that makes a difference, of course, too. But any words of wisdom or suggestions that you could
yeah.
pass on?
So Gene, I how can I put this? I when I was on the corporate business side, right, and we were in lawsuits, and a lawyer would come to me and say, "Hey, the judge is ordering mediation, or would you consider mediation?" I'm going to tell you, like, I had a pretty dim view of that, right? And it was really because of my own lack of sophistication, my own lack of appreciation of the value of mediation. I didn't come into mediation because I had amazing, wonderful experiences with it. To the contrary, it's not that I had bad experiences with it. I just felt like I, I just thought, oh, well, that's just sort of a split the baby thing, right? And I don't want to split the baby. Like I want, I want to win, or I want some creative solution that someone that doesn't understand my industry is not going to be able to help us do. And that was sort of a short coming on my part. So I would encourage general counsel to really do a better job than the general counsel I worked with promoting the value of mediation within the company, both to the executives, within the other lawyers. We've had recently, I think we had Cynthia Randall from Microsoft. Excellent example of an in-house lawyer who has a deep understanding for the value that mediation can bring to corporate disputes. And on the mediator side, in dealing with general counsel, the main thing that you have to do is to be able to convince that general counsel that you understand their role, you understand their business, you're deeply interested in the precedent that any resolution might have, notwithstanding confidentiality provisions. I think it's fair to say within most companies, people think that whatever settlement is reached will ultimately become known by whoever wants to know it. And so those are the two sides of that coin that as I think about mediation and general counsel.
Any suggestion for the mediator on how to quickly overcome the negative implication or the negative thoughts that the corporate client representative might have coming into a mediation?
Look, I think the main thing is to say, look, we can find, only in my view, only the least sophisticated mediators are going to say, okay, one side wants 10 and the other side wants 100, so my goal is to drive it to 50 or 55, right? That it's about explaining to the general counsel, or the general counsel within his company, like a really good mediator is a business partner for both sides in a commercial litigation, right? And that the most sophisticated solutions can be crafted for sure. And it's not a split the baby sort of, to use that terrible phrase. It's not just an exercise in finding the economic midpoint, right? And I would focus on that, on the creativity that can be brought into the process.
Sounds great. Thank you so much. Well, it's we've got maybe 1 minute left or so to the top of the hour. Unless someone has a really fast question, Michael, do you want to use it to say whatever your last few comments might be, and then?
Oh, just thank you, Jean. Just thank you for having me. This has been a lot of fun, and I hope it provided some amount of value for the folks that took their time today to tune in.
Well, thank you so much for being here. Thank you everyone for being here, and thank you for whatever donation, large or small, you can make to any food bank, and in particular, if you to the Los Angeles Regional Food Bank. And if you would please be so kind as to let one of us know the amount of your donation, we will anonymously add it to our running total with great pleasure. And there is a link on our website. Look, you can see upcoming speakers, just like you look for what movies go out and when they're coming. You might look at that, willworkforfood.news, okay? And it's great being here with you today. Thank you so much, and thank you all. Bye-bye.
Thank you.